We'll start when they show up.
I want to take my whip.
I'll bring my
What do you have? What is that?
well, I got a big walking stick, so I could pick it up and whack them with it. Good morning, Rotarians and guests. Welcome to the Rotary Club of Hudson. Ron Strobel, the Sergeant at Arms. Our invocation this morning is by Jim Ahern. I know he's here. Jim. Glad you could make it.
What am I supposed to do? Oh, never mind. Good morning. Please stand. You know, in looking up invocations, you can get online and find a lot of invocations. Specifically, there's a number of them from Rotary clubs. And sometimes you get right into the Rotary Club site to look at it. Well, this one is from Rotary Club of Furniture Land. Rotary Club of Furniture Land. High Point, South Carolina or North Carolina. No, yeah, okay, North Carolina. But anyway, I think most of them work at the largest furniture store in the world. Furniture Land South. So 1.3 million square feet, pretty cool. Oh, please bow your heads. We pray for the bifocals of faith so that we can see the concerns of the moment right under our noses, but also see further on the important and critical long-term issues that will play such an important part in all of our children's futures. Father, in working out your plan in the world, we ask for your guidance in this request. Again, Lord, we pray for the ability to see at close range what can be our part as a group to become solution partners in the giving today of our time, our efforts, and our money. We pray also for the ability to see clearly in the distance, along with those who are in Rotary partnership with us. May we look with a new vision through the bifocals of faith and then act accordingly. Amen.
Thank you, Jim. And lead us in the pledge and the four-way test, Dan Filburn.
Good morning, Rotarians. Okay, pledge allegiance to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Now let's have the four-way test of things we think, say, and do. 1, is it the truth? 2, is it fair to all concerned? 3, we build goodwill and better friendships for would be beneficial to all concerned. Thank you.
Thank you, Dan. We have one visiting Rotarian this morning, Barbara Marshall, Three Rivers, Michigan. She's in education administration. Welcome. And now our president, Father Joe Boisel.
Thank you, Ron. Good morning, Rotarians and guests. I just have one announcement, and that is that next Wednesday, the 9th, following this meeting, there will be a board meeting. So board of directors meeting next Wednesday following this meeting. And then I'm going to bring up Rich, and he's going to tell us about our fall fundraiser. It's going to last 7 days, right? I mean, God created the whole world in 7 days. Why not have a fall fundraiser that takes 7 days, right? It just, you know.
Thank you, brother and Father Joe. And thank you for having me this morning. Let us bow our heads. No, we did that already. This is in reference to our fall fundraiser in memory of Mr. Tom Page. And since Tom's passed away, we've had a couple successful years. Thank you, everyone, for participating. And we encourage everyone to continue to do so. So in lieu of wanting to fill out this beautiful sheet that Pat put together for us, probably on his computer at home, we would encourage you, if you don't want to participate, to do a net contribution of $100. We kindly ask of that. We are not demanding it, but we kindly ask of that amount. So if you have a sheet, you'll see there is caramel popcorn in your first selection. And Pat would like these sheets back for the popcorn by November 9th. And it doesn't leave you a lot of time. Not his fault, just turnaround time is the issue. And then we had a little delay on the flowers, but we finally got through to the people in charge. Or if you want a flower arrangement, that would be $35. So we welcome you to fill out this sheet, turn it back in, either Pat or I. I believe we can go another week out if you're interested in the flowers. I'm confirming that with the lady, because I want to make sure the turnaround time is going to be there for all of you. I believe, not have my calendar in front of me, we're talking about the Tuesday, the 8th is when I think, I can't speak for Pat, is that correct also? More sensitive on the flowers because they start to go bad. Is Tuesday the 8th? December, that I will be picked. December, yeah. Whatever that Tuesday is before the 6th, I will be picking up the flowers. Marilyn, I know you were there last year because you want to get yours for your people that you sign up. You're welcome to come with me again. And anybody else, because there are a lot of flowers that we need to pick up. I'm assuming that everybody is going to participate in that area. So I would say, Pat, by December 6th, we'll get the flowers. And then if you want to coordinate the popcorn at the same time, we'll have them ready for December 7th. Okay, so let's go with that for now. Sorry for the delay. We had a little lack of communication on the flower arrangement. I know you're probably thinking that's Rich's fault, but it just didn't happen right away like we wanted to. So anyway, it is all set, guaranteed the pricing on it, and they also guaranteed the turn. Well, they told us the guarantee time would be the turnaround time wouldn't be a problem. So that pretty much wraps up the fall fundraiser for now. Please get these in once again to either Patrick or I. Pat's been a big help from being the support of the two of us. And I want to thank Patrick for that. And then there was one other thing I want to say, but I'm getting a little forgetful about this. If I think of it later, I'll blurt it out. But we do encourage participation.
How big is that caramel corn? I don't remember. Is it okay. So it's I'm sorry, full tub? Okay.
Yeah, in case Joe's asking what happened to the cheese popcorn. Foundation, correct. Great question, Joe. Thank you for reminding me. And yeah, and we don't know, I don't know if we have a record of how many people actually ordered cheese popcorn last year. It seems like caramel popcorn was more of a, Mimi? You did? Are you gonna be able to switch your taste this year, girl? Well, then just buy flowers instead. It's a higher and like it. Mr. Basil? Yeah. I believe Pat told me this morning is a $8 profit built in on the popcorn. And I got the flowers for the same price as last year, which is not bad in today's changes in the world. So the pop for the flowers is $20 is our cost. So there's 15 built into the flowers and 8 built into the popcorn, right, Patrick? Is that what you wanted to hear? I know I just gave away our profit, but I'm sorry, Mimi. He emailed me, today's Wednesday. I think he emailed me Monday going, what's up? You know, when are we going to know so I can get my people involved? So who's in charge of getting that to them? You want me to email a sheet this to Marty, right? Okay, I'll try to remember to email a sheet to Marty so he can start getting, because they're a big help. Oh, I know what I was going to say. See, if you talk long enough, it comes back to you. Our revenues last year was just short of 10,000 on this. Our revenues on this event was just short of $10,000. I think it was 9,800. And then our cost was just short of 3,000. So there's a built-in profit about $6,800 from last year. Yeah. So revenues means
That goes to, yeah, I know.
means receipts.
Okay. All right.
It goes to scholarships. Okay, I babbled on too long, so that's it. Thank you for having me.
I'd like to. Yes, well done.
One last thing for Joe Avella. This was not script, so I did this on the fly.
No, you're kidding. I thought you had that written down. And when he said, we kindly encourage you to give $100 contribution, it reminds me like priests in the Anglican Church have to take a vow of obedience to our bishop. And the bishops try not to wield it too heavily. So they'll say things like, Joe, it'd really bless me if you would do this or that, which means you better do this or that. So it would really bless us if you gave $100 net contribution. All right. What else was I having? There seemed like one other thing. Tom, help me out. I'm sorry. I could sell indulgences. I'm not beyond it. Despite my reformed motto, I still like profit. So yeah, if you want to see me later. There seemed like there was something else that I'm forgetting, but I can't remember what it is. So maybe like Rich, if I keep talking, it'll come back to me. I don't think so. Cash does not go in your pocket. It goes to me. Ron? Yes, Stan, let's welcome you back to the Rotary Club. Ew. I'm sorry. Okay, Mandy's coming up and she's going to introduce our speaker.
All right, it's hard to follow all of that. Danielle Frye is an attorney at Krugliak, Wilkins, Griffiths, and Dougherty. Danny went to Kent State University for undergrad, where she graduated in 2013 with a degree in psychology and justice studies. She then attended the University of Akron School of Law and obtained her Juris Doctorate in 2017, graduating summa cum laude. Throughout law school, Danielle worked at our firm, Krugliak Wilkins, and upon passing the Ohio bar exam in 2017, she was hired on full-time. Immediately after the Ohio bar, Danielle took the Florida bar exam and became licensed in both Ohio and Florida. Deanie concentrates her practice in the area of estate planning, including the creation and administration of trust, drafting wills, powers of attorneys, and other estate planning documents. Deanie also is a leader in the firm in probate administration and planning for elders. In 2018, Danny married her high school sweetheart and they live in Uniontown with their cat Junior. And Danielle is also one of my best friends and we work together. And so I will turn it over to her.
Good morning, everyone. I am here today to talk to you about estate planning. So I welcome you to interrupt me if you have questions throughout, but I will open it up for questions at the end of the presentation as well. From a global view, estate planning is planning for things that occurred during your life, but also when you pass away. So during lifetime, if you become incapacitated, you're unable to handle your own financial affairs or unable to make your own healthcare decisions. Powers of attorney are the documents that would allow you to designate a person or persons to make those decisions for you. And then, of course, after you pass away, estate planning does involve making sure that your affairs are in order, that your assets pass in the manner that you wish, and that you have the decision makers in place that you would like to handle those types of things. If you could go to the next slide, please. So powers of attorney, I mentioned those obviously briefly in the last slide, but there are two types of powers of attorney. And the reason for that is because the law looks at us as a puzzle of two pieces. There's your personhood, so decisions about what healthcare you're receiving, where you're residing, things that you as a person would be able to decide about your physical being. And then there's also your estate. So not your estate in the sense of after you've passed away, your assets to be administered, but really what you own, your property, things that you can do on the financial side of things. And so if you were to become incapacitated and you're over the age of 18 and you don't have estate planning documents in place, what could result is you could end up in the probate court with guardians appointed. And so under the probate court, there are two types of guardians. There's a guardian of the person that again controls the personhood, and a guardian of the estate that controls your finances. So the reason we have two types of powers of attorney is to cover both of those scenarios, so that if you become incapacitated, about 99% of the time we can avoid having to go to the probate court and have a guardian appointed on your behalf to act for you. So just as it sounds, the power of attorney for property allows you to designate someone to handle your day-to-day financial affairs, making sure your bills are paid, making sure your income tax returns are filed, taking required minimum distributions on your retirement accounts, anything that you would do on your property side of things. Also, in powers of attorney for property, a decent or a good estate planner will include powers that expressly authorize your agent to do advanced planning for you in the event you're unable. We're going to talk a little bit towards the end of the presentation about long-term care planning, but in Ohio and in most states that have adopted the Uniform Power of Attorney Act, there are certain things that involve making changes to your estate plan. And if your power of attorney document does not authorize your agent to do those things, we're somewhat limited if you become incapacitated and you're not able to do your own planning. Okay, so that is something important to think about. Oh, if you could go back, I just have to talk about the healthcare power of attorney first. So the power of attorney for healthcare, that's a document that actually doesn't become effective until a doctor determines you are not able to make your own healthcare decisions. So it's something that you want to have in place, but as long as you are able to decide what healthcare you're receiving, where you're residing, then that document will not come into play. But again, it makes sense to have that in place because we don't want to end up in a guardianship through the probate court if we can avoid that. Okay, now the next slide, please. Thanks. Okay, so a lot of people have heard about a document called a living will, and that's not to be confused with the last will and testament. For some reason, us attorneys wanted to make those documents sound the same when they are in fact very different. Now, when you go to the title bureau, when you're updating your license, or typically if you go into your primary care provider, or if you go in for an outpatient procedure, they will ask, do you have a healthcare power of attorney? do you have a living will? So everyone assumes that you're supposed to have both of those documents, when in fact, a living will is actually optional. A living will relates only to end-of-life situations. So when you are essentially determined to be at the end stage of a terminal illness or permanently unconscious, as determined by two physicians, your living will at that point, if you have one, would kick in. And the doctors legally, after providing notice to the individuals you've listed on the living will, they have the authority to withdraw life support on your behalf because you've directed them to do that in advance in your living will document. Okay. For those individuals that don't have a living will, that end of life decision would fall to your agent under your healthcare power of attorney. Okay. So that's kind of how they conflict with each other. Essentially, the living will with respect to end of life situations would trump your healthcare power of attorney. Okay. Next slide, please. Now we have the last will and testament. So we're kind of transitioning from decisions that occur during life when you're not able to handle your own affairs to after you've passed away. So your will doesn't become effective until you pass away. You could change it every single day if you wanted. A lot of people think that a will avoids the probate court, a last will and testament. It in fact does not. A last will and testament directs how assets that pass through probate will be administered. A lot of times when I meet with clients, one of their main goals is to avoid the probate court. The probate court's not the end of the world, but it's pretty easy to avoid and it takes time. There has to be an attorney involved, which everyone loves working with attorneys, and you have to pay court costs and attorney's fees. And so a lot of times, if you're dealing with a loss of a loved one, and now you have an attorney and the judge telling you what you have to do with respect to that loved one's property, you know, it's just not a good situation. And so if we can avoid it, it makes things a little bit easier. It makes a difficult situation a little bit easier. But even if you have everything set up to avoid probate, it's still good to have a will, because if you don't have a will, the laws of Ohio says what happens when you pass away if something happens to pass through probate. The will is the only document where you can actually name an executor. And so sometimes we have the need to appoint an executor for something, even if we don't have to go through probate. Sometimes if a final tax return has to be filed, or, you know, we have a refund check that passes through someone's probate estate, we still want to have an executor designated, because again, if not, Ohio law says who gets to serve in that capacity for you. Next slide, please. Okay, so I touched on this a little bit, but you know, we're going to talk now about the difference between probate and non-probate, or assets that pass outside of probate administration. So essentially, probate is the process through which assets are transferred at an individual's death, unless there is an arrangement set up to allow those assets to pass outside of probate. That's a really confusing definition, but what you want to think about is there a contractual arrangement in place that will allow my assets to pass without having to deal with the probate court? Okay, and so some examples are, if you have assets that are owned or designated to pass to a trust. We're going to talk about trusts on the next slide, but a trust is just a fancy word for an estate planning contract. So we have that contractual arrangement, we avoid probate. Okay, assets that are owned jointly with rights of survivorship. So my residence is titled with my husband, joint with rights of survivorship. That means when one of us passes away, it will pass to the survivor of us without having to go through probate. Okay. Assets that have a beneficiary designation. So this would be life insurance, retirement accounts. You know, most of the time when you're setting up those types of assets, when you acquire those assets, you're asked to complete a beneficiary designation form. So even if I had a will that designates my husband as my beneficiary, if I got a life insurance policy when I was 20 years old that designated my mom as the beneficiary, that contractual arrangement is going to control. It won't pass through my will and pass to my husband. It will in fact pass to my mom. And then finally, assets that have a transfer on death or payable on death beneficiary. So in Ohio, you can actually name a beneficiary on every type of asset. You can name a beneficiary on a vehicle. You can name a beneficiary on real estate. There's a document referred to as a transfer on death designation affidavit, where you can actually say, when I pass away, if I still own this piece of property, I want it to pass to X beneficiary. So you can really do a great job of avoiding probate by just looking at each of your assets and making sure that they are aligned to pass to a beneficiary when you pass away, okay? I touched on this a little bit before, but the reason we like to avoid probate if we can is because it results in costs and attorney's fees. Most types of probate administration have to have an attorney involved. So you're paying those fees as well as the costs to have the administration done through the probate court. Anything that goes through probate administration is a public record. So a lot of times when I'm working with clients that have business interests, for example, they don't want their valuations or information about their business to be public record. So oftentimes we will include a trust to make sure that we avoid probate with respect to those types of assets. And probate takes time. I would say on average, probate administration takes 9 months to a year to complete. And so a lot of times if there's family members that need access to the asset that's in probate, they're very limited because you can't get access to those funds quickly. Next slide, please. Okay, so trust planning. As I mentioned before, a trust is just a fancy word for an estate planning contract, but the actual definition is that trust is a legal document that provides for the administration or distribution of trust property, okay? There's different types of trusts. Generally, when we're dealing with estate planning, the type of trust that we work with is an inter vivos trust or a trust that's created during lifetime. You can create a trust within a will, but a lot of times we try to avoid that because one of the reasons for having a trust is to not go through the probate court. And if you create a trust in the will, you end up in probate court either way. So we typically will not include testamentary trust as part of plans. And then there's also the difference between a revocable and an irrevocable trust. For general probate avoidance, the type of trust that we use is a revocable trust. That means that you can make changes to it. So a lot of times, we'll meet with clients, we put in a revocable trust in place, and they'll review it every 3 to 5 years, or when there's a change of circumstance. And if things are different than the last time we put documents in place, we can update it. And that's what's nice. As your situation changes, either with respect to your family or your finances, you're able to make changes to your document. It's a fluid document. An irrevocable trust is used for advanced planning. So that could be in the form of long-term care planning to preserve assets in the event you need to transition into long-term care in the future. It can also be used for estate and gift tax planning. So right now, the estate tax exemption is over $12 million per person, which is doubled if you're a married couple. So it does not apply to most of the population. But for those individuals that need to plan to preserve from being taxed on their estate, they would use an irrevocable trust for that. The benefits of trust planning in general, but more specifically with respect to a revocable trust, allows for the management of assets. It makes administration of your assets easier in the event you become incapacitated or when you pass away. Again, we avoid probate. So that, again, is most of the time one of the main goals for my clients. It does provide privacy because whatever passes through a trust would not be subject to the probate court and therefore be public record. And then again, it provides flexibility. We can do a lot of things within a trust instrument, preserving assets for your children, for example. You can basically structure a trust such that it's a built-in prenuptial agreement. It would preserve assets in the event your child gets divorced. Whatever is left in that trust would not be subject to division in the event of a divorce. And it ensures when your child passes away, that whatever's left in the trust would go on down to your descendants and maybe not to a spouse that you don't particularly enjoy. Okay, next slide. Okay, So planning for long-term care, this has become more and more popular type of planning technique recently. I would say probably within the last 10 years. But the reason for that, I think, is because individuals are living longer and the cost of care is pretty, expensive. It's pretty costly. As you can see right now, the average cost in Ohio for long-term care is over $7,000 a month. I would say in this area, Stark, Summit, Portage County, that's probably closer to $8,500 a month, just based on the facilities that we work with. In most cases, we can do planning in advance to attempt to preserve assets in the event you or a loved one needs to transition into some type of long-term care. And so that could be in the form of home services, it could be in the form of assisted living, or it could be full skilled nursing, so an actual nursing home. What you want to look for if you want to do that type of planning is an attorney that concentrates in the area of elder law. There are a lot of estate planning attorneys, but not all of them concentrate also in long-term care elder law planning. Next slide, please. So it's really difficult to talk about long-term care planning without talking about Medicaid, because most of the time when we're doing the long-term care planning, it is in order to allow us to more quickly qualify for public benefits that might be available to us. And in this context, that public benefit is Medicaid. That's not to be confused with Medicare. Everyone over a certain age can qualify for Medicare. Medicaid is a little bit more difficult to qualify for. So generally speaking, what Medicaid will look at for purposes of eligibility is to make sure that you have a continuous period of its institutionalization. It has to be more than 30 days that you are considered institutionalized. So that could be in a hospital, that could be an assisted living facility, it could be in a full skilled nursing facility. You have to be within a facility that accepts Medicaid. So there are a lot of private assisted living and skilled nursing facilities that are simply private pay. They do not accept Medicaid recipients. Then there's a level of care requirement. So there's certain activities of daily living that you have to need assistance with in order to qualify. They will look at your income and your resources, and there's different requirements for both of those, and no transfer penalties. So I don't know, most people with a limited knowledge of Medicaid have at least heard about the 5-year look back rule. If you don't transfer assets within 5 years, then Medicaid can get your house. That's what I hear, a lot about. So that is something that they will look at. And right now for Medicaid eligibility, the period that they consider is 5 years. Okay, we're going to get to that a little bit more on the next couple slides. So next slide, please. So this is really what long-term care planning focuses on as far as those eligibility requirements. This is what we're focusing on. So when Medicaid looks at your assets, as a single individual, you are permitted to have $2,000 in your name in order to qualify for Medicaid. If you have more than that, you do not qualify, which means that you are paying privately at a facility that might be charging $8,500 a month. Okay. There are certain exempt assets in certain situations. If you have a spouse that is residing at your residence, the residence is not considered as part of that $2,000. If you have a burial space or some type of contract that will provide for making sure your funeral expenses are paid after you pass away, that's considered an exempt asset. Your tangible personal property, your things, that's protected. They don't count that against you. You're permitted to keep one vehicle, term life insurance, because it does not have a cash value. So you couldn't go to the life insurance policy, the life insurance company and say, give me the money that's the cash value, because there is none. And then certain trusts. So that's where the planning part comes in, because the attorney can create a trust that meets the requirements of Medicaid. Next slide, please. I mentioned earlier, there's some special rules for spouses. So generally, what happens when you're attempting to qualify for Medicaid is Medicaid will take a snapshot. They take a picture of your assets, okay? I usually am able to draw this out for my clients. I don't have a whiteboard or anything, but so Medicaid will take a snapshot of your assets and they chop that asset, pool into two pieces, okay? The residence, again, is not included. Tangible personal property is not included, and a vehicle is not included. But everything else that is considered an asset, so your investments, savings accounts, whole life insurance, everything else would be included in this snapshot. And they chop it into two pieces, okay? On the spouse that stays at home, that's referred to as the community spouse. On their side, they get to keep $137,000. On the institutionalized spouse's side, the one that is in the institution, the nursing home, they get to keep $2,000. So in order to actually get us down to those limits, we have to spend the money on permissible things, or we just have to continue to pay the nursing home $8,500 a month until we're at those levels and we can qualify for Medicaid. Okay, this is really confusing. A lot of times I have to work with my clients on this, for a couple of sessions for them to completely understand how it works, because it's super abstract and the rules change. You'll see that those numbers were updated as of January this year. They'll probably change within the next couple months. So things will continue to change. Next slide, please. So in order to lessen the amount of funds that we have in that snapshot, what we can do is advanced planning, 5-year planning. And essentially what that involves is transferring assets out of the applicant's name or the applicant's spouse's name into someone else's name or into an irrevocable trust. If you make that transfer and you get beyond the 5-year period before you have to qualify for Medicaid, then that transfer is not counted against you, okay? And so oftentimes what we'll do is we will create an irrevocable trust with maybe one or more children as the trustees and the children as the beneficiaries, or it could be another loved one that you trust. And you would transfer assets into that trust more than 5 years before we might need Medicaid. Now, there's always planning that can be done. If somebody, we see this unfortunately all too much, where there's some type of diagnosis, and the prognosis is 6 months before we have to go to a nursing home. And so that doesn't give us the 5 years, but we can always do planning. But really the goal is to get assets out of your name more than 5 years before you have to qualify for Medicaid. Next slide, please. Another thing to consider when you're doing Medicaid or long-term care planning is a recipient in Ohio that is receiving Medicaid. When they pass away, anything that is in their name is subject to Medicaid estate recovery, meaning to the extent Medicaid has paid for your care, they can come after your personal assets to get reimbursed for those. If those assets are in a trust, an irrevocable trust that you've done for advanced planning purposes, they can't be recovered because they weren't owned by the individual when they pass away. But we do have a lot of times where clients had a loved one that was receiving Medicaid and they get a letter in the mail 6 months, maybe a year after their death, and Medicaid's trying to pursue assets. And it happens a lot because, the state looks at it as, well, we're providing this coverage for you, we're paying for your expenses. If you had anything left over that was beyond what covered your funeral expenses, then we're going to attempt to recover that. Again, I know Medicaid and the long-term care planning is extremely abstract. It's really difficult to think about and especially explain in a, 15, 20-minute presentation. But that's all I have for today. So I will open it up for questions. If anybody has a question, you might all just be too confused, and that's okay. I hope I didn't make it more confusing for you. No?
Thank you so much for coming. I
Okay.
really appreciate it. And it's fascinating. I wondered what made you be interested in this type of law? I mean, you didn't want to go make arguments and that sort of thing?
Absolutely not.
Yeah, all right.
Yeah, anybody that knows me, I don't like confrontation. I do not like the litigious aspect of law at all. My undergrad was in psychology, and up until my final semester of undergrad, my plan was to go and obtain my PhD in clinical psychology. I wanted to be a psychologist. But then I got involved in research, which is, it's very, it takes a lot of time, and it wasn't very interesting to me. And as part of a clinical program, most of what you do is research. And so at that point, with an undergraduate degree in psychology, there's really not much you can do besides go to grad school or work in retail. So I decided, because I had a justice studies degree as well, that I might take, the LSAT. I did well, and I ended up in law school. So that's how it worked out.
All right, follow up. Do
Yeah.
you get good energy? Are you energized by what you do now? Do you enjoy it?
I enjoy it. I think that I get to, it's different than litigation. Clients sometimes actually enjoy working with me because they know that they're doing what's best for their family and getting their affairs taken and, taken care of, so that they're not leaving their family with a mess. And so I really like being able to work directly with individuals and make an impact. And a lot of times, and I've only been with Krugliak 7 years now, but we develop relationships with the family. So it might be multiple generations that I get to work with. And if you think about it, that's a lot, it has a lot to do with psychology, because I'm dealing with people that have lost a loved one. So there's, the grieving side to it. So I do enjoy what I do.
So we, up until COVID, we used to meet at Laurel Lake Retirement Community, which I don't believe they take Medicaid.
I think that's correct.
So I have a lot of more familiarity with that sort of thing. How many, in your world, how many people are doing the things to qualify for Medicaid?
So
Other than just, girding their loins to pay the high fees.
I would say that the number of people that are interested in doing this type of planning is increasing. It sounds crazy, but really the sweet spot, as far as assets, we're looking at individuals that have from $500,000 to a few million. Because if you think about it, if we're spending $100,000 a year, we have some type of diagnosis where physically we're healthy, but we could reside in a long-term care facility for 10 years. That is a significant amount of money. And so, it really depends on the situation. A lot of times clients are not comfortable giving up control of the assets by putting them into a trust, and that's okay too. It's really a personal choice, but it's good for everyone to have the knowledge about how Medicaid works, and the planning options available.
And while Rich is coming up here, let me ask you, where does charitable planning fit into estate planning for you?
So I have worked with individuals. A lot of time, individuals do provide for charitable gifts in their estate planning documents, whether that's a percentage of the whole. Sometimes individuals just decide to name a charity as a beneficiary on retirement accounts because there's an income tax benefit to that. And sometimes it's a backup beneficiary. So if I don't have any descendants, I would prefer that my assets go to a charity, more so than maybe my third cousin that I've met once in my life. And so I've done planning for individuals that want to gift to charities, but I've also worked closely with certain private foundations that actually, administer donor advised funds and various funds. So I do have some exposure to that as well.
Thank you for coming. Thank you. I know, I got to bring it down to this level, Joe. Thank you for coming this morning. Nice thing about walking up here, you can see the back of your head on the screen. But anyway, two questions. One's gift tax. The other one is, you mentioned getting your assets down below 2,000, give or take, those other things that are on the list. If you have an annuity, I'd say you left $100,000 annuity in your mother's name, just so she can feel good about it. And it pays out like, say, $5,000 a year. you'd have to cash in that annuity when you go into a facility?
Yes and no. It depends. So you can create a special type of annuity, so you can convert an annuity into a Medicaid compliant annuity. That's an option. But a lot of times, because we want the flexibility of having liquid assets, we do recommend that the annuity be cashed out. Unfortunately, there's probably an income tax ramification to that. But there is a special type of trust, and I didn't touch on this again because it's pretty abstract, but there's a type of trust in Ohio called a pooled trust, like a swimming pool, POOLED. If I wanted, I could cash out all of my assets today, gift those assets into this special type of trust that can be used for my benefit during my lifetime. And I could qualify for Medicaid tomorrow. That 5-year transfer penalty does not apply to a pooled trust. The catch is whatever's left in that trust when I pass away is subject to the Medicaid estate recovery that I mentioned. So it's essentially allowing you to put those funds aside to be used for additional things like clothing, furniture, haircuts, the things that Medicaid doesn't cover, with the hope that you'll spend that down during your lifetime, but whatever's left over does get reimbursed to Medicaid. So, there's different options with respect to annuities. I will point out, because this is kind of a similar type of asset in Ohio now, and this is a very new rule within the last year. A retirement account used to be treated as a resource, meaning it was subject to the $2,000 spend down. But recently there's a new rule, and it's been interpreted to allow individuals that are taking their required minimum distribution. So if you are taking a distribution from that account, it is no longer treated as a resource, but it is instead treated as income. Okay. And so that's been actually very beneficial. It's logical. We thought as attorneys, as practitioners, that should have been the rule for a really long time. But at least with retirement accounts, that new rule is in place, and so far has been interpreted to favor the resident, the applicant, for Medicaid purposes.
Thank you for explaining that. And when you happen to golf with a bunch of guys out at Firestone, you get this next question asked all the time. TOD accounts.
Yes.
In case you didn't know what TOD means, transfer on death.
That was on the slide. You could have just been reading, not listening to a word I said. And you would have
Well, Father Joe likes to take early morning naps, so so let's say you have $100,000 and it's just you as a kid and you have a couple kids yourself and father and mother getting sick, whatever, and they're concerned about going into a facility, and the account gets set up as TOD, transfer on death. Well, I guess the question is twofold. To be able to do a TOD account set up with your father, could you well, actually the mother's alive too, so it's father, mother. Could you do a consent gift for mother and father to Sonny Boy and Sonny Boy's 2 kids? And that way you can get 32. You can almost get to that 100, or does that even matter with a TOD? And the second part about a TOD, and I'll leave and turn the microphone over to Jim Ahern, is can the facility grab a TOD account?
So I might have a follow-up before you hand the microphone away, because I want to make sure I'm understanding. Okay, so are you asking so that account is maybe currently titled in mom and dad's name?
Correct.
Okay, and you want to know if there's a TOD designation, if it remains in mom and dad's name, would that still be subject to the spend down if they needed to qualify for Medicaid?
That and
yes. So the answer to that is yes.
Okay.
But an alternative would be to gift that account now, to give it to Sonny Boy or to the grandchildren, with the understanding that if we don't make it 5 years before mom and dad, have to transition,
right,
those funds might have to be gifted back or used for mom and dad's care.
And that's called the clawback provision?
Yeah, that's called the look back.
Okay.
I think you also want to know, because of the numbers that you were discussing with respect to gift tax. So right now, because of the federal estate tax exemption, again, that's over $12 million per person. You could gift that much during lifetime with never having to pay tax on it. There is an annual exclusion amount. Right now, that is $16,000 per person, which is doubled for a married couple. And that's actually going to go up to $17,000 next year. But you can gift that amount without even having to take it from your $12 million exemption. So that's a lot of times what people are thinking on, that it used to be $15,000 for a long time. But now it's $16,000. So again, most of us that are doing planning for the long-term care, we're not in the $12 million range. So we don't have to worry about gift and estate tax. I hope that's what you're, and then
Make one last comment about that. And in order to do the consent gift, you have to file the 709 form.
you should. When you gift the assets, we want to show some type of record showing that you're making a gift of the asset. There are some accountants that take the position, as long as you're under the annual exclusion amount per beneficiary, that you don't have to file a gift tax return. I'm not an accountant, so I will defer to the wonderful CPAs out there to provide you direction on that.
Thank you for coming. I'll shut him off. I had one question. Now I have two. On TODs, can you create one document that sort of laundry lists property and everything that you would like listed? Can it be in just one revocable document?
Yeah. So generally when we have clients that have, unique wishes or, more specific wishes than I just want everything to go equally to my children. We typically will suggest that they do a revocable trust, because essentially what we would do in that scenario is we would take all of the assets and we would name the trust as the TOD beneficiary. And then the trust would gather all the assets when the individual passes away, and it would be up to the trustee to say, okay, this account or X number of dollars will go to this beneficiary. And then the balance goes equally to Joe and Jim.
So if you set up a revocable trust with another attorney, any other attorney can just make an adjustment without having to redo the whole.
Correct.
Whole thing. Okay.
Yeah.
Here's my real question, and it's an opinion question. I went through, my parents had long-term care insurance for, I'm 15 plus years. In their circumstances, both of them are different, but both ended up the same. The long-term care insurance provided little value based on their circumstances at the end, based on things we learned well after when they would have needed it. What's your opinion? If someone says, should I buy long-term care insurance? Tell me your opinion.
Nowadays, unfortunately, long-term care insurance premiums are extremely costly. If Mandy and I wanted to go out and get long-term care insurance policies, we could probably get affordable policies with affordable premiums. The problem is a lot of these companies, because in years past, they would actually make money on these policies, but now most of them are paying out and sometimes completely going out of business. And so they will continue to increase the premiums to a point where it's just not cost effective for a family to keep those in place. So, if you have a policy currently in place, I would say it's worth getting that policy reviewed to determine whether it's worth keeping those policies, going. But unfortunately, just for, a regular person to go out and get long-term care insurance, it's probably not going to be cost effective.
Tom Tobin mentioned something I wasn't real clear about with a continuing care retirement center, which is what Laurel Lake is an example of. And in that case, it's a form of long-term care insurance, but and I am curious about that's why Medicaid doesn't recognize it, because what you're doing when you go to a place like that is equivalently putting the price of a house of some sort into your, as a buy-in.
Mhm.
And then if you run out of money because you live too long, that's where the support for end-of-life care comes from.
Sure.
And unless you live there, I believe if you live there for less than 5 years, you might get some of that back if you decide to leave the premises. But otherwise, the money stays.
Mhm.
So it's a crapshoot in a way. But that's why there's no Medicare at those kinds of facilities. Am I
Yeah,
correct,
so
Doctor?
there are some continuous care facilities that do accept Medicaid, but generally speaking, how it was explained, that's accurate. You know, you go in maybe in an independent living type setting, then maybe you transition to assisted living, and then ultimately at some point you could transition into full skilled nursing. And those, most of those types of facilities do have some type of nonprofit organization component to them, such that once you are no longer able to continue paying for your care, that's when the nonprofit entity kicks in and will cover those costs. So absolutely, if that's an option, typically those facilities are nicer because there are individuals that are paying out of pocket for that. And then again, they also have the foundation, the nonprofit organization component to them. So yeah, it's definitely something that you can consider. But it's really just, you know, a preference for you and your family as to whether we'd prefer to be in a facility long-term and not have the ability to get kicked out, or do we want the focus to be to preserve as many assets as possible and qualify for Medicaid sooner? And it's a personal preference.
Hi, Danielle. Great presentation.
Thanks.
Okay, quick question and little activity for the room that I'm curious about. And in my work as a financial advisor, one thing that I see in regards to Medicaid planning is that when is the right time? Like when is the right time to start giving away your money, basically? And that's what you're doing, whether you're giving it away or giving up control, et cetera. So what percentage of people are concerned about their assets being depleted for their care in your experience? And then for the room, let's have a raise of hands for folks that might consider or think about giving away their money in terms of signing up for Medicaid.
So again, the individuals interested in learning about this type of planning or doing this type of planning has increased since I began my practice. A lot of times, you know, the individuals that are aware because they've dealt with the situation with a family member, they're obviously more eager to do the planning because they don't want it to happen to them. I have individuals pre-retirement age that are ready to come in and give away their assets. And typically I advise against that because once you're retired, we're more able to create a budget. We know what your steady income is going to be from Social Security, pensions, retirement accounts, that type of thing. And we know what your assets are. If you're still working and generating assets, it's a little bit difficult for us to say, okay, it's time for you to give up your house. But so I would say most of the time we start talking about it. And when I'm meeting with clients, if they're post-retirement, I will at least mention the possibility for long-term care planning in the meeting. The most important thing that anybody can do with respect to long-term care planning, if you're not ready to move forward now, is making sure that you have a good power of attorney for property in place. So that if you do have some type of incident, whether it be a fall or some type of cognitive issue that develops quickly and progresses quickly, you have documents in place that would allow a family member or loved one to do that planning for you. Thank you so much.
So much. And now I know what TOD stands for. I'm going to drop that at lunch today, with somebody around, and I'll look really learned, won't I? That'll be super clever. All right, Ben is coming up to. So our Rhoda Buck raffle payout today is $8, and jackpot 241. Danielle, can I get you to pull a card, ticket. That's the word I'm looking for. I know what TOD's.
Oh, okay. 599851.
Oh, so close. Oh, Sergeant.
This is getting to be a
Thank
pretty
you.
regular thing.
Yeah, right?
Thank you.
Were you last week as well? Let's say that Jack.
Yeah.
Oh. No, no chance today. Well, everybody, have a great day. Thank you again, Danielle, for coming and sharing with us. It was fascinating. Have a great day. Make a difference in somebody's life. Be great. Yeah.